Thank you, Lascian Corda. And I think it's my first opportunity to congratulate you on your election. I know you'll do a superb job. I'm very pleased to have the opportunity to deal with an important piece of legislation. This is a criminal justice bill. And I think all of us have to be very careful when we're enacting criminal law. It's an emergency bill. It has not followed the normal path of legislation for very understandable reasons. There's no published explanatory memorandum. There's no pre-legislative scrutiny. We're going to have very little opportunity to have a committee stage debate because the deadline for submitting amendments at committee stage actually was this morning at 11, before the second stage debate could be had and before we can ask questions or listen to the views of the Minister. Now, in general circumstances, all of that would be entirely unacceptable, particularly for a criminal justice piece of legislation. And we have supported it, this Parliament, and the vast majority of people in it, all the efforts of the government to deal with issues that have arisen to combat the pandemic that has befallen the world, but obviously bestrides our own country, and we need to continue to do that. But we need to bring the people with us in that endeavour. We need to be clear on what we're about, and we need to be very open in what is law and what is not law. It is clear to me that this particular piece of legislation is a reaction to some of the events that have happened. I suppose most especially to the horrifying views that people had of a situation in Dublin, where a barman stood on a bar counter pouring vodka down the throats of clients. And people assumed that that could be acted upon. But of course, the only criminal sanction that the guards have is if that particular premises hadn't been selling food and provided €9 of food to every one of its clients. The rest of the activities are mere guidelines. They're not criminalised in any piece of legislation. So a lot of what we're doing is basically giving guidelines to people and sometimes pretending that these have the force of law. I think we need to be very clear and very honest with the people. What is criminal and what is not? There's also concern that there seems to be a view of government that when they're producing legislation like this, that they have to spin it to the public before they explain it to the Parliament. And that really is unacceptable in my view. For example, when it was clear last Friday that this Dáil was going to be recalled, largely because of the so-called Golfgate event, this legislation was to be the centrepiece of this week's Dáil business. But on Friday, we were told that part of the legislation would criminalise gatherings of more than 6 people in a private dwelling, and there would be power given to An Garda Síochána to pursue such people. Now, the Minister has said that was never their intention subsequently, but somebody briefed very authoritative journalists in the Irish Times last Friday because that's where it was laid out. And we've read subsequently that actually it was being pursued by the Minister for Health, but abandoned because it was felt by the Taoiseach and others that it was going too far. We really need to bring the members of this House with the government in relation to all these matters, because we have common purpose and we have common view, and the notion of spinning is not acceptable. And in terms of even the legislation, we read on Friday as well that, for example, it was going to be made compulsory for face masks to be worn by staff members of pubs. And that's not either in the regulations that were published yesterday, but maybe they are to be. We don't know. So that really gets on to the point I made this morning, Lascian Corla, and I want to make clearly with the Minister. You see, this is very unusual criminal legislation. It is criminal legislation that sets out mechanisms to enforce and the penalties to be applied, but doesn't actually specify the crime. Now, in any other piece of criminal legislation, the offence is laid out, and at the end, the penalty is laid out for committing the offence, and how the Garda Síochána are to enforce that. But in the briefing we had with the Minister's officials last Friday, it is clear that there is two different departments. The Minister's Department and the Department of Justice setting out the criminal sanctions for breaches of the regulations. In other words, the penalties for committing the crime. But the crime is to be set out by the Minister for Health, who is not here. So we don't actually know, and I listened carefully to the Minister's speech, what specifically is to be criminalised, either now or into the future. And that is a very dangerous thing to be doing in relation to criminal legislation, because what's at stake here is the removal of the livelihoods of people. And our initial reaction, as it has been from our colleagues in Sinn Féin, is we will stand foursquare behind the government in ensuring that so-called rogue operators are stamped out. But two things. One, we must be clear in what we are doing. And two, we must bring the public with us in understanding that, and not pretend that offences are offences when they're not. And as I say, there is in essence two parts of the proposals before the House. There is the justice, criminal sanctions, and then there is the crimes, if you like, the offences to be set out in regulations made by the Minister for Health. I asked the Minister for Justice's officials at the briefing on Friday, well, what specifically are the offences? Where are the regs? And they told me these are the crafters of the legislation before us, that they don't know. And I've never dealt with a situation where the crafters of the legislation didn't know what the crimes that are being legislated against specifically were. They said that was a matter for the Minister for Health, and they would be published on Monday. Now, in fact, the Minister for Health did sign regulations yesterday, and it's 14 pages of regulations. See, the difficulty with the regulations is that some of them are what are known as penal, and some of them are not penal. Now, what is the difference? In essence, non-penal regulations are entirely advisory. Nobody can enforce them. The penal regulations are ones that are enforceable, and there is a school of view, a very strong school of view in jurisprudence, that a law that is not enforceable is not a law at all. So regulations that actually don't carry a penal sanction are not regulations. And I understand that, some things are advisory. For example, we're not going in this House to make it a criminal offence not to, when you sneeze, not to use your elbow. But it would be a criminal offence to sneeze into somebody's face. And I understand you make that discernment. But a lot of the reaction we've had in terms of the COVID restrictions are pretense. We pretend that we're doing things that we're not. And I think we just need absolute clarity in relation to that. And if I can, Lascan Cola, just take you through the 14 pages of regulations that were signed by the Minister for Health yesterday, and see which are penal and which are not, as far as I can discern today. Regulation 5 applies to events in private dwellings, no more than 6 persons, from no more than 3 households. But that's not a penal regulation. So it's unenforceable, either civilly or criminally, despite the utterances of the Taoiseach that the Minister for Health can prosecute you. There's no such, I've checked with lawyers, there's no such capacity. So it's merely advisory. And if this is not the case, maybe the Minister for Justice would be very clear in what is the difference between penal and the non-penal. Regulation 7 applies to cinemas, art galleries, museums, auditorium, with stage and fixed seating. The maximum attendance is 50. Again, It's not a penal provision. Regulation 8 applies to weddings and imposes a maximum attendance of 50, including staff. Again, it's not a penal provision. So there's no enforceable powers. Regulation 9 is also non-penal, covering sporting events, limits necessary persons, participants, subs, coaches, medics, and so on. Regulation 10 covers training. Again, it's a non-penal regulation. They're all encompassed in the same statutory instrument, SI 326 of 2020, published yesterday. But some of them are mere advisory, and some of them have the force of law. And we need to be very clear on what we're doing here. What is penal and will have the force of law? Well, Regulation 6 restricts social, recreational, exercise, cultural, entertainment or community events other than those dealt with specifically above, and persons attending those must confine themselves to 6 indoors and 15 outdoors. This is the non-private house ones. Regulation 11 covers alcohol venues and bans, continues the ban that's already there on casinos, nightclubs and pubs where there is no meal served. And they are penal provisions. A new closing time of 11:30 for pubs and restaurants is introduced in these new regulations, Regulations 11 and 12. Of course, off-licences are excluded, and that is a penal provision. And Regulation 13 provides that with effect from tomorrow, the 3rd of September, businesses and services where drink is served for consumption on the premises must keep records of the time and date of arrival of customers and a record of the substantial meals ordered. Food and drink must be consumed while seated at a table. And again, that's a penal provision that is the force of law. So, the other aspects of the regulations, for example, social distancing, other than you must consume your food at your table, which is a penal provision, but the maintenance of 6 feet is not a penal provision, and it's unenforceable. The amount of time, the guidelines of being there for an hour and a half, is not a penal provision, and it's advisory. So if the guards go in, and if I'm sitting in the pub, and I've had my €9 of food, and the proprietor has signed me in, there's no reason why I couldn't stay there for 5 or 6 hours, as far as I can see. Other than the guard might say, I'll object to the licence because it's breaching the substance of the guidelines, but not the penal regulations. So, I raise these issues because I think it really is important that when we're creating law that we have very clear clarity in relation to what we are creating. And I would invite the Minister when she's finished, because one of the problems that we have in this legislation, again, which is very unusual in creating criminal law, and I absolutely accept this is a timelined emergency piece of legislation that will end in November. But the Minister for Health keeps the power to create new offences under this. So it's very unusual that criminal offences can be created by statutory instrument, even on a temporary basis. And I think we just need to be very clear on what we do as legislators, even when we all want to do right by our people in this time of pandemic. We have to maintain the authority of this House and the confidence of the people that we're maintaining the proper procedures so that we act wisely, proportionately, and in accordance with best international practice. I do want to pick up the point made, I read in one of the, one of the interviews I think the Minister for Justice gave this morning. She said that this might open the way for those so-called wet pubs to be opened, and I welcome that, because I raised with the then Minister for Health, Minister Harris, the very strange decision that somehow serving, as I said at the time, a cottage pie or a chicken korma was a prophylactic against COVID. It made no sense to me. If the regulations in terms of restrictions and guidelines were maintained in one house, they can be maintained in another house, and the eating of food is neither here nor there in that context, in my judgment. And I think it had the adverse effect of actually restricting the number of premises, therefore concentrating the clientele in fewer premises, which was, I think, was a bad thing. So I hope that this law will allow for all premises that are properly regulated, that are properly monitored in terms of COVID guidelines, to be reopened. But I do think it is important for the Minister, in terms of setting out clearly to us, and it wasn't done in her opening statement, what are the penal regulations that will be encompassed by this bill, because I think it would be a minimum requirement for members of Dáil Éireann to know, if we're creating criminal offences, what the offences are. I think that's hardly an outrageous request. And if there are further regulations to be made, how are they to be made? Obviously, the capacity is because the Minister can, under the 1947 Act, create new regulations. And we amended earlier that Act to provide the Minister for Health with the capacity to create COVID regulations, including penal COVID regulations. So we need to know exactly what is intended by government to be encompassed by this bill. As far as I can read it, and I'd like the Minister to be very clear, what is included here in criminal sanction will be a requirement, one, for the proprietor to take note of the lead person in any group or any individual who is coming in and a contact for contact tracing purposes. Note of the food ordered by that individual, presumably so that An Garda Síochána can check that if they came onto the premises. And the regulation that food ordered and alcohol ordered must be consumed at the table that the person is at. But what about the other regulations and guidelines that are there, in terms of social distancing, in terms of wearing masks by staff, in terms of serving drink at the bar counter? Are they mere guidelines, or are they to be enforceable too? Because I think the people need to understand what is being required of us by the laws that we make. I think that the very basic requirement of any decisions we make in this House is that they're clearly understood by our own people, and we can explain them ourselves to people. Because I remember, was it the Church of Ireland bishop earlier in the year got very annoyed when he discovered that the confinement of 17-year-olds, over 70s, was actually advisory and it didn't have the force of law. So we have to be clear: what is advisory? What is enforceable by penal sanctions? So that when we set out, our strategy for dealing with the reopening of licensed premises, that people do it on a very clear understanding. And I'd hope that the Minister would do that in her closing statement. Maybe she doesn't know, of course, what the intention of the Minister for Health is in this regard, because it is a different department and there are different sets of advisors. Certainly, as I say, when I asked her own advisors who briefed us last week, they weren't privy to the actual regulations that were going to be penal in the Minister and what he intended to do for that. And my final thing I'll say is this: is in everything we do, at this critical juncture, we have to maintain the confidence of the people. I don't think anybody would doubt for a second that has been very seriously eroded by some of the goings-on of the last couple of weeks, particularly by the Oireachtas Golf Society. We need to win that back. And part of winning that back is being very clear and very upfront and very honest in what we intend to do, how we intend to do it. And I would hope that the Labour Party would be able to support this legislation, but we do it on the basis of complete openness from the Minister and complete clarity in what exactly is intended to be regulated and what exactly is intended to have penal sanction. Good magat.